Hearing the appeal of Paul and another against Royal Wolverhampton NHS Trust, Polmear and another against Royal Cornwall Hospital NHS Trust, against Ahmed.
Yes, Mr. Weir.
Well, please, my Lord, Lord Briggs and the Chair, my Lady, Lady Rose and my Lords, I appeal on behalf of the appellants in Paul, in this case, from the learned friend Miss Johnson of King's Counsel, the learned friend Mr. Tyack, who's immediately to my left, appears on behalf of the appellants in Purchase, leading Ms. Gamble, and learned friend Mr. Pitchers of King's Counsel, who's very kindly sat back there only to allow us a bit more space, and I will retract tomorrow, and he will come and occupy this space tomorrow. Appears on.
You to wave your arms around a little bit more.
Which is that to be encouraged, my Lord?
Oh, absolutely.
But then I shall endeavour to do so. Leads Mr. May for the appellants in Polmear, and my learned friend Mr. Maskery of King's Counsel, well known to this court, leads Mr. Baggett of King's Counsel and Ms. Jones for the respondents, all of them.
Thank you. Before we go any further,
yes, my Lord.
Because we're having extended sitting times to accommodate the 3.5-day estimate within 3 days,
yes,
we can't sit on Friday, I'm afraid. We'll take a short break at a time of Council's choosing, but halfway through the morning session and halfway through the afternoon session. We're not, I think, provisionally all that convinced that we need quite as much time as been allocated, and we very much hope that Council for the various claimants have worked out to avoid repeating each other in a way that should shorten matters. It may be, and we'll review the position as we go along, that we can step back from the extended sitting hours if we can do a bit better than the timetable suggests we'll be doing.
My Lord, yes.
But please don't feel you have to spend your allotted time. I'm sure you won't.
Barrister's natural inclination, my Lord.
Of course, the other thing about a generous time allocation is I'm afraid you're going to have to submit yourselves to lots of barking from the bench,
my Lord,
or injury time, depending on what phrase you use for it.
That's what you say, except your lordships may not call it that, or your ladyship. Well, may it please the court, this appeal concerns the law of negligence. More specifically, claims for pure psychiatric illness brought by secondary victims. That is, claims in which the claimant suffered only psychiatric injury and was not in the range of foreseeable physical injury, and in which the psychiatric injury was caused by witnessing a horrifying event of injury to the primary victim. And we're just pausing there, uniquely in my experience, but very possibly not abnormally, questions were set for us yesterday afternoon.
Yes. Well, not uniquely in ours.
No, not in yours, my Lord, not in yours.
There have been times we've only done it during the first 15 minutes of the hearing, but we thought it would be fairer to give you slightly more.
I'm extremely grateful. It may be that before I go any further in relation to how I propose to set out the submissions I make, it's quite convenient, because I've just referenced there the business of primary and secondary victims. It's quite convenient, if that's of assistance to the court, for me to seek to answer
by all means
the questions which we were set. So in answer to those questions, and first of all, can I just check, my Lord, that you have the version that we've sent in of Powell and Boldats, and also D and East Berks, which my learned friends, I think Mr. Tyack sent through electronically, which should come through, because I'll reference both of them in short order.
Yeah.
And I'll reference the Powell case in the version that we've sent through. A patient is a primary victim, just as is the person knocked over by a car or the employee hit on the head by racking. That's because all those claimants are within the range of foreseeable physical injury. See Page and Smith, and I only need to give you the reference in our case, which is paragraph 13 at page 130. It matters not that the breach involves an omission, because doctors assume a responsibility to diagnose and treat patients, and so are liable on entirely conventional grounds for omissions as well as commissions. Otherwise, a patient who's got a pre-existing illness, which is the norm, going to hospital, could simply not be treated. It would be a case of omission, but no liability, which would be an extraordinary state of affairs. And for this, if you kindly go to the very important judgment of Robinson and the speech or judgment of Lord Reed.
Just before we do, you're talking about the relationship here between the doctor and the primary.
I am.
Yeah.
That's. But the second part of the question says, does it make a difference that it's an omission case? And so I'm tapping into that before then stepping back to go to secondary victims. So if the court will kindly go to page 1199, 1199.
Yes.
Paragraph 34 in the judgment of Lord Reed, he sets out the basis upon which a defendant can be liable for omissions. And he does so by essentially approving an article from Tavares and Steele, and in particular, if you look at the quote, in a tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of danger not created by A, unless A has assumed a responsibility to protect B from that danger, and that is the doctor-patient relationship. That's completely normal. So that adds nothing, that it's an omission, not a commission case. It's a commission case in shorter, a judgment we're going to look at later.
Well, obviously it doesn't for the primary victim, but the point is that Lord Oliver says you've got to show an independent duty of care owed to the secondary victim.
Oh, absolutely. But absolutely, which I come to. But in relation to the interaction, if I can put it that way, between primary and secondary victims, we sought to sort of set out how that works in our case, early doors, which started at page 130. It explains the observation of my Lord Legate, see at page 130, paragraph 14, that an independent duty of care is required to be established between the claimant, now secondary victim we're looking at, so it's page 130, paragraph 14, first sentence. Does the court have that? And the defendant. But at the same time, if you go over the page to paragraphs 15 and following, we seek to set out in that section, but I won't, if you give you time to read it now, I'll just summarise the position. The breach of duty in relation to the primary victim is the breach of duty in relation to the secondary victim. Well,
where's the duty in relation to the secondary victim?
Oh, my Lord, that's the issue on this appeal. Can I just...
Oh, sorry, you're starting with the breach before the duty.
I'm starting with the breach because I'm dealing with the point about omission, my Lord.
Right.
The point about it being an omission is your Lordship's asking a question. When a breach is by omission, what is the significance of that? My answer is that there is no significance that attaches to that. The breach in relation to the primary victim, brackets, whether it be by commission or omission, is the breach in relation to the secondary victim. In other words, if you establish a breach in relation to the primary victim, that stage has been passed. Doesn't matter whether it was by omission or commission. That's how it works in the secondary victim world. We've sought to set it out to you in a bit more detail. It's not a derivative claim, it's an independent cause of action, but they're linked in that way.
But in what sense has the doctor assumed a responsibility to protect the secondary victim, the relative, from the danger of witnessing something that happens to the first victim? I'm just picking up the language of the article by Tavares and Steele.
Yes, my Lord. The basis of that is the basis of secondary victim claims. In other words, the subject of this appeal. That's the whole point. If you just go for these purposes to D and E Sparks, if you can kindly draw up that PDF. And you'll have it numbered by way of electronic numbering, forgive me, but I've got a hard copy. But if you can kindly work your way through to what is in fact paragraph 107, which is more than three quarters, I'd say, we're about three quarters of the way through. It's paragraph 107 in D&E Sparks.
We're going to give us any kind of page number?
It's page
And we're all operating, all 7 of us, from...
Yes, I'm sorry, it's only the additional one I got this morning, my Lord. I'm sorry. It's the only, I'm good otherwise. Okay. On page now. It's an additional PDF. Right. Thank you for taking me to task, my Lord, in relation to that.
Page 40.
Yeah.
Page 40, my Lord.
Thank you.
Page 40. Deanie Sparks is a case involving the question whether or not there's a duty of care in relation to social services for decisions relating to taking a child into care or not, and whether an independent duty was owed to the parent as well as to the child. And in short order, there wasn't, because it would put the social services in conflict because they're principal duties to the child and they can't have a conflicting duty to the parent. But if you go to 107, the judgment of Lord Roger, and just have a look at that, and can you kindly scan read that paragraph? To similar effect, can you kindly then go on to page 48? Then in the judgment of Lord Brown, paragraph 133. That's page 48, paragraph 133. Both paragraphs referencing the case of Walters, which is a very important case to which I'll be returning in due course. So that is in response to the observation of my Lord Sales, that is how it works. Normally the duty is owed to the primary victim in doctor-patient relationship, as in a road accident, it's owed to the primary victim. But there is a body of case law which has established duties owed to secondary victims, and that body of case law is the subject of this appeal. So being asked a question, well, why or how, is asking the question, how do we say we're going to win? And that's the submissions I'm going to develop through the course of today.
But in the case of the road accident or an act like that, you don't need an assumption of responsibility if you drive negligently and you injure people. You owe a duty of care to most people you injure. Then there's a certain question of how far the consequences of that extend. And there we have principles in Alcock for people who suffer consequential psychiatric harm. But I don't see how you could just leave out the step of an assumption of responsibility in the medical negligence case, where it's a question of omission.
Well, you can have a road accident that could be treated as a case of omission, because you could say failed to indicate and then turned left. But
it isn't an omission.
I totally understand, my Lord.
That's not how it's analysed,
I totally
even though it may involve
it's the
omission.
act of driving, my Lord.
That's right.
I totally understand it's the act of driving, but my point is simply, when you are in a world where there is a recognised conventional duty, whether it's omission or commission, doesn't matter. It does not matter at all. The doctor owes a duty to protect the patient in relation to the illness which the patient turns up at hospital.
That's right, and the doctor does not owe a duty to the patient's relatives to protect the patient.
My Lord, no, save and save.
Or to protect the relatives.
Save in specific circumstances. Those circumstances, as set out by Lord Roger and Lord Brown, include a clinical negligence case called Walters, in the clinical negligence setting, involving an omission case. There is no...
Well, I'm not sure that question was discussed in the Walters case. I understand it wasn't discussed. We'll probably be coming to that.
I understand it wasn't discussed, but... forgive me, but this is so clearly not an issue in this case.
Well, you say that, but it's not being confronted, as far as I can see.
My Lord,
Walters is the only case that seems to be to support the contrary view, and it doesn't seem to have been looked at in that case.
My Lord, it cannot matter if there is a breach of duty to the primary victim. That's the step. It's the same breach of duty in every secondary victim case which is applied.
Does there have to be a breach of duty to the primary victim? I thought you could have a secondary victim case with no liability in the case to the primary victim.
You can, my Lord. You can have cases of a traumatic event external to the primary victim, witnessed by the secondary victim, who is in fear for the safety of the primary victim, brackets, who actually is unhurt.
That would be no claim by the primary.
That would be no claim, but
Not necessarily no breach of duty.
were one to ask the academic question was what was a breach of duty had the primary victim been injured, it would be the same breach of duty. That's the point. All pleadings throughout my practice in secondary victim claims correctly plead one set of breach of duties in relation to the primary and secondary victims.
Well, then that doesn't seem to me to be taking seriously the suggestion that it's an independent duty of care that has to be shown.
It does, my lord.
It's treating it as essentially a derivative form of action in which you're up and away if you prove a breach, a duty of care owed to the primary victim.
Up and away, my lord, if you establish the relevant duty of care, which is the big issue in this case, what is it that's necessary to establish a duty of care owed by the defendant to the secondary victim? And that's why in due course, my lord, forgive me, but I would probably seek to move on to develop my submissions. In due course, can I invite your lordship just to read, as I say, from page 130 onwards in our written case, when we've sought to set out, if I can put it this way, how it works, and it does work.
Can I see if I can understand the precise way in which it is being put? I think you're being challenged as to the question whether the doctor assumes responsibility to the relatives who suffer the psychiatric illness. That might be one way of looking at it, and it could be that the answer is that the law is assuming that there is that assumption of responsibility by the doctor. But I'm not sure that that is your answer, because as I understand it, what your answer is that in the secondary victim psychiatric illness cases, they are based on an independent duty of care, but there are aspects of derivative nature being taken into account, and this is one of them. That is, that although it's an independent duty of care, it includes a feature of a derivative action, insofar as you're only bothered so long as there's been a breach of the duty of care to the primary victim.
My lord, respectfully, I concur.
And that's just the way it's developed.
That is how it's developed, and it's worked for a long time.
And if we didn't accept that, we'd have to wipe out a lot of what's already happened.
We're reinventing the wheel. And
it would also mean there would never be a claim for psychiatric illness in any medical negligence case by a secondary victim.
it leads to a series of startling consequences, my lord, none of which are tolerable or in any way consistent with the principle of justice which underlies the whole of this, and fairness. Respectfully. I don't think it's strictly necessary to go to the Powell and Boldat's case, but Powell and Boldat's case was the aspirational claim of an independent and novel duty of care based on a so-called some kind of freestanding duty of candour. That's page 10 of the version of the report that we've sent through, which itself was recognised by the Court of Appeal to be quite independent of the secondary victim claims which had been settled. So if you go back to page 4, left-hand column, more than halfway down, your lordships and your ladyship will see, and panic disorder suffered by the second plaintiff caused by witnessing the pain, suffering and subsequent death of Robert. And then just below that, the claim by the first plaintiff for damages for PTSD caused by events prior to his death has now been settled. Lower down, the other claim was not. And you see into column, right-hand column, it's clear the settlement must have included a substantial figure. And that was a settlement, if you go on to page 9, right-hand column, where they've actually sidebarred it, the third sidebar down. So far as Mrs. Powell is concerned, I agree with Mr. Prynne of Queen's Counsel for the respondents that any exacerbation to her condition from subsequent events ought to be compensated for as part of her claim as a secondary victim witnessing a trauma of Robert's suffering and death. So that was a claim in which there was a fatal accident claim in relation to the child. There were secondary victim claims, entirely conventional, one of which was dropped, no doubt on its facts. Perhaps it wasn't horrifying for that claimant or didn't have a recognisable psychiatric illness or whatever. The other was settled for a large sum. And then this case is about, can I invent a new duty of care answer from the Court of Appeal, no, you cannot in that case. And that's the end of Powell and Boldats. My Lord, with that foray into hoping to address the questions of the court, can I now seek to develop my introduction so your lordships and ladyship have some idea where I'm hoping to go in relation to my submissions. In Alcock and Chief Constable of South York's Police, the House of Lords provided authoritative guidance in relation to much of the law in this area. And the context for that case was a tragedy involving what I will refer to as a traumatic event external to both the secondary victims and the primary victims, with a breach of duty, which as far as I can tell, because breach of duty was admitted, occurred on the day of the tragedy in the immediate lead up to it by not controlling the flow of spectators into the stadium. So we've got a breach of duty immediately, if you like, followed by a traumatic event external to the secondary victims and primary victims. The context of these appeals is different. And before I come to that context, can I make a preliminary submission, which is that subject to intervention from the court, I propose to make my submissions exclusively in relation to the Paul appeal. I do not intend to trespass into the Polmear and Purchase cases at all. And our appeal is conjoined with those, and it may be said to involve relevant factual distinctions, and certainly has, and I believe still does, involve very different ways of putting our case before the court. The consequence of that is that I would invite the court to be very careful when hearing submissions from my learned friend for the respondents, because the respondents' written case groups the appellants together. You will not see reference to Paul separate from reference to Polmear and Purchase. But can I respectfully invite this court to have in mind at all times the separate submissions that we make in Paul, given much of the criticism of the respondent seems, at least to us, to be aimed at a different target, namely the respectfully extreme position which certainly in the Court of Appeal the appellants in Polmear and Purchase have adopted. And that is not the position which we are adopting. Focusing now just on the case of Paul, the court is here being asked to consider a case in the clinical negligence setting involving delay. So that's delay first between the respondent's breach of duty and the accrual of the primary victim's cause of action. And further delay between such accrual of the primary victim's cause of action and the first manifestation of damage to the primary victim when he had his cardiac arrest, which was the horrifying event, the cause of the appellant's psychiatric illnesses. And that is a materially different factual scenario to the one facing the House of Lords in both Alcock and McLaughlin. And the question for this court, in my respectful submission, is how to apply the law of negligence in this situation, armed with the guidance thus far, principally from the House of Lords in Alcock. In terms of the submissions I propose to make, my lady and my lords, it's under the following headings. First, it will be the appellant's case in outline. Secondly, how this is an area calling for flexibility so as to achieve justice, and the respondent is respectfully wrong to suggest a shadow of exceptionality is cast over all secondary victim claims. Thirdly, how there is no requirement for an event external to the primary victim. Fourthly, how the appellant's case is consistent with a line of Court of Appeal and High Court authorities going back more than 20 years, and the respondent's case is not. Fifthly, how the appellant's case does not involve overruling Taylor and Novo, or indeed any other case outcome. So far as we can tell from checking, no case outcome in the bundle of domestic cases before this court we say needs to be said to be wrongly decided. The reasoning in relation to at least one of them, that's a separate issue, because as we know in Taylor and Somerset there were two reasons given by Mr Justice Ord as he then was. But one of them is a good reason. But the outcome in all the cases we do not object to, we do not say is wrong, and is not inconsistent with our case. And finally, how this court can articulate a flexible test which provides a fair outcome without A, trespassing into the arena left for Parliament, and B, giving rise to open-ended liability of the ultramarine and touche type. So if it's all right, I'll start with the appellant's case in outline, and I propose here to make submissions under three headings. The first is the backdrop to the determination of the point of law, namely the assumed facts of this case. And as your lordships and ladyship know, this is a strikeout application, so the pleaded facts are the facts for the purposes of this appeal only. Secondly, the importance of establishing legal proximity, and thirdly, how legal proximity is established in the case of Paul. For the backdrop to the determination of point of law and the facts of the case, we've set them out, just so your lordships and ladyship have the reference, at pages 129 to 130 of our case. I'm now going to summarise them. First of all, there was a failure to diagnose significant coronary artery disease in the primary victim in November 2012. And this was silent. By which I mean, first, it was a case of breach by omission. Secondly, consistently with that, the primary victim was none the wiser. He didn't know there'd been a breach of duty. And that's what I mean by silent. He turns up to hospital, he leaves hospital. He doesn't know that he's not been diagnosed with a condition of significant coronary artery disease. As a direct result of that breach of duty, in fact what happened is the primary victim's significant coronary artery disease was left untreated and caused his cardiac arrest in January 2014. Which cardiac arrest was witnessed by the appellants in this action, which experience was shocking to them, and which experience caused them both to suffer recognisable psychiatric illnesses. And none of this is an issue for the purposes of this appeal. Next, the primary victim's cause of action will have accrued sometime after November 2012 and before January 2014. And it will have accrued when, on a counterfactual analysis, had the proper diagnosis been made, the primary victim would have been treated. So he wasn't diagnosed with a significant coronary artery disease. He should have been diagnosed, and he should then have been treated for it. And when he would, on the counterfactual analysis, have been treated, he would have got better. In other words, his position would have changed, and so it's damaged by not getting better as opposed to damaged by getting worse. And that certainly was common ground between the parties at the time the case was heard by Mr. Justice Chamberlain. And here can I invite you, please, to go to page 338. 338. paragraph 55, you're in the judgment of Mr. Justice Chamberlain in the High Court, when the appellant was now the respondent. In this case, there was on the appellant's case a completed tort as soon as, in breach of duty, the respondent negligently failed to arrange a coronary angiography and instead decided to discharge Mr. Poole on the 12th of November 2012. Some damage was occasioned to him on that day, but a failure to improve or stabilise his condition, or at the very least to prevent it from worsening. And then there's reference to a case called Dryden in the Supreme Court, which I don't need to take you to, because from the Court of Appeal onwards, we accepted the analysis that damage had occurred to the primary victim, which completed the primary victim's cause of action before the cardiac arrest, because that has to be right in order for the claimant to succeed on causation.
I mean, very strictly, Mr. Justice Chamberlain is saying the cause of action accrues on the 12th of November.
Yes, it doesn't approve on the 12th of November per se. I mean, whether the date...
I don't think it matters.
Exactly, my lord, exactly. Whether
just
it's
very slightly
December or January, within a month or two, however long it takes him to treat. But it accrues before January 2014, because that's what enables the secondary victim claimant to say, I win on causation. Had you not acted in breach of duty, none of this would have occurred. The cardiac arrest wouldn't have occurred. It wouldn't have occurred because you would have treated the primary victim before the cardiac arrest occurs. That accrual of the primary victim's cause of action will also have been silent, because we're now on the counterfactual. Nothing happened. We're looking at what should have happened had the defendant not conducted itself in breach of duty. And now linking the breach to the cardiac arrest from the perspective of the doctor. And this isn't rushing ahead to look at breach after the existence of a duty, because this is how one looks when we come to it at the issue of legal proximity. You look at reasonable foreseeability and proximity from the time of the date of breach. That's when you look and you ask yourselves questions about reasonable foreseeability and contemplation. First, it was eminently foreseeable that a failure to diagnose and so treat a patient for significant coronary artery disease might well lead them to suffer cardiac arrest. And secondly, it was also reasonably foreseeable that any such cardiac arrest, if witnessed by close family members, might occasion psychiatric damage to them. And if you kindly just go back to the judgment of Mr. Justice Chamberlain, and to page 342, paragraph 68, slightly more than halfway down the page. So 342, 68, not all of them are sudden and shocking events, but some are. I would regard it as the court see that, I would regard it as eminently foreseeable that a negligent failure to diagnose and treat a heart condition might result in a sudden shocking event that, if witnessed by close family members, might occasion psychiatric damage. And I should add, it is common ground in this case, on this appeal, that the threshold of reasonable foreseeability as between claimant and defendant, so that's claimant, secondary victim and defendant, has been passed for the purposes of the appeal.
Where do we find that?
I will find it, my lady. I actually...
Just say it again.
Yes, of course. But I can assure the court, but I will repeat it. It's common ground that the threshold of reasonable foreseeability as between the claimant and defendant, so that's the secondary victim claimant, has been passed for the purposes of this appeal. And we'll give you chapter and verse. And I cannot see learning from Mr. Maskery gnashing his teeth as I make the submission, though he may or may not be a gnasher by disposition.
If it assists, we do not say that there is an absence of reasonable foreseeability. But we do say that reasonable foreseeability is not the test for legal proximity.
With which we agree, for the avoidance of any further doubts. And Thirdly, and importantly, it would be expected to be in the contemplation of the careless doctor that if he or she did not diagnose a patient correctly with significant coronary artery disease, that patient was liable to go on to develop the classic consequences of such disease, namely cardiac arrest. And finally, for the purposes of this appeal, the cardiac arrest must be taken to be, or to have been, the first manifestation of injury to the primary victim. And the reference in the particulars of claim is at page 383. 383, if you can kindly turn that up. It's in the statement of facts and issues, but at 38, you'll see the actual basis for it here. At 383, para 45, you'll see particulars of secondary victim claims of the second and third claimants, and then you'll see the deceased daughters were 9 and 12 when they witnessed their father's death. They had a close tie of love and affection with the deceased. They were present for his collapse, attempts at resuscitation, and probably his death. The event they witnessed was the first manifestation of the defendant's breach of duty.
Can I just ask, the second proposition about reasonable contemplation, why is that being put forward in relation to a tort claim where one would have thought all the work was being done on this issue by the concept of reasonable foreseeability? Why are you adding in reasonable contemplation?
Well, it's not reasonable contemplation.
Contemplation.
It was looking at the facts of this case before moving on to the issue of legal proximity. So I was addressing it as a warm-up to the submission I'm now going to make in relation to legal proximity, my Lord.
Right, thank you.
Because my next heading was the importance of establishing legal proximity, and in line with the submission just made by my learned friend Mr. Maskery, we readily accept the need for legal proximity, which is proximity between the claimant secondary victim and the defendant. And for some reference to this, because although it's common ground, it's an important issue, it is really where the appeal gets started, can I please invite you into the judgment of Lord Wilberforce in McLaughlin at page 5. I've got a reference there that's not a good one. I'll just find it, my Lord. Yes, it's page 597 of the bundle, please. 597. So at 597F, the court will see, just after a reference to the famous dictum of Lord Atkin and Donoghue and Stevenson, that is saying that foreseeability must be accompanied and limited by the law's judgment as to persons who ought, according to its standards of value or justice, to have been in contemplation. That is language which we now say legal proximity. But the language which has been employed by Lord Wilberforce is important because he references according to its standards of value or justice, which is why I'm able to make the submission I made briefly earlier about how riding roughshod over the established law would simply lead to an unjust outcome which is not to be tolerated. And it was Lord Wilberforce, if you kindly go on to 599A, who introduced what came to be known as the control mechanisms. So right at the top of that, the A, you'll see Lord Wilberforce saying, 3 lines down, it is necessary to consider 3 elements inherent in any claim: the class of persons whose claim should be recognised, the proximity of such persons to the accident, and the means by which the shock is caused. And that was the genesis, if you will, of the subsequent judgment in Alcock, because Alcock was essentially followed Lord Wilberforce in McLaughlin. And in Alcock, Lord Oliver referred to more than once the need for a sufficient relationship of proximity in order to found the relevant duty of care. And if you can kindly go to page 568, 568. Down at H. So what Lord Oliver says between G and H, in essence, this involves answering the twin questions of A, whether injury of this sort to each particular plaintiff was a reasonably foreseeable consequence of the, and I just note here, acts or omissions constituting the breach of duty to the primary victim, which simply emphasises how it matters not for these purposes and how it operates by way of reference to the breach of duty to the primary victim, and B, whether there existed between a defendant and each plaintiff that degree of directness or proximity necessary to establish liability. Here we are entirely ad idem with the respondents.
Is he saying that that degree of proximity has to exist at the time of breach? I think he is, but
you measure it at the time of breach,
yeah.
Because with the benefit of hindsight, it's not a purely prospective analysis. You don't purely prospectively look at reasonable foreseeability because you're looking at it in relation to the damage that occurred. You may be asking yourself a question whether it's of a kind of damage for which was reasonably foreseeable, but you're looking at it in relation to what occurred. And we get this theme coming through again. If you can kindly go to 572 at F. You'll see just after F, it must, as it seems to me, be attributable simply to the fact that such persons are not in contemplation of law in a relationship of sufficient proximity to or directness with the tortfeasor as to give rise to a duty of care. That's a case that when it's not working.
I'm so sorry, which page is that?
572 at
I've got it
F.
on page, thank you.
And then if your lordship stays there, when you start at a new paragraph, what is more difficult to account for is why, when the law in general declines to extend the areas of compensation to those whose injury arises only from circumstances of relationship to the primary victim, an exception has arisen in those cases in which the event of injury to the primary victim has been actually witnessed by the plaintiff, and the injury claimed is established as stemming from that fact. Such an exception exists. That such an exception exists is now too well established to be called in question. What is less clear, however, is the ambit of the duty, or, put another way, what is the essential characteristic of such cases that marks them off from those cases of injury to uninvolved persons in which the law denies any remedy for injury of precisely the same sort. This is Lord Oliver grappling with the very same, if I can put it this way, preliminary questions that this court asked of counsel in writing yesterday. And this is Lord Oliver saying, we understand that we're in an unusual area because normally you're going to owe the duty to the primary victim only, but there is a body of case law long established now which does provide a remedy to so-called secondary victims in certain circumstances. He then asks himself the question, why is that? And he answers it at 573E. And very important, this, very important. And you see, he says, the answer, if your lordships and ladyship can see that, the answer has, as it seems to me, to be found in the existence of, and can I emphasise these words, a combination of circumstances from which the necessary degree of proximity between the plaintiff and the defendant can be deduced. That the court will have regard to a combination of circumstances is entirely of a piece with the need for flexibility in this area, a theme which I shall develop later. And the response of their lordships in Alcock in real terms as to how and when the requisite degree of proximity was to be deduced was by reference to the same control mechanisms that Lord Wilberforce had identified in McLaughlin. And that is so was pithily put by Lord Dyson in Taylor and Novo. If you can kindly go to page 636. 636. Paragraph 28. So 636, please. In which Lord Dyson says, I accept the submissions of counsel for the defendant that the correct question is whether Ms. Taylor and Novo are in a relationship of proximity in the legal sense. The difficulty in answering the question is, as Lord Oliver said, the concept of proximity depends more on the court's perception of what is the reasonable area for the imposition of liability than any process of logic. In the context of claims by secondary victims, the control mechanisms are the judicial response to how this area should be defined. So that answers now completely the first question of the court yesterday in writing. Why is it that we're allowed to claim? Because we say we come within the control mechanisms as this court should, respectfully, we say, understand them to be operating in this particular context.
And the control mechanisms, as you're suggesting, are effectively the same issue as whether there is legal proximity.
My Lord, yes.
They're one and the same. I think in the Court of Appeal, Lord Justice Voss indicated that he didn't like the terminology of control mechanisms, or somebody did.
Yes, your Lordship's right. He said that, but it's a very suitable and satisfactory, my respectful submission, because they limit. We've seen that from Lord Wilberforce and from Lord Oliver. They limit. You have reasonable foreseeability, but you limit it. Yeah. This is, in other words, controlling the extent of liability so as to ensure that you don't have unlimited liability, because unlimited liability is the problem.
I mean, I suppose you might say that in McLaughlin O'Brien, one had a sort of Anns and Merton model and reasonable foreseeability, policy reasons why you would cut back, and that therefore was very much perhaps the Wilberforce way of looking at it, whereas perhaps now that model's gone, you might say it's more grounded up and therefore more on proximity. But it comes to the same thing.
My Lord,
yeah.
And it's also the same question as to whether a duty of care is owed then.
It's exactly the same question. In relation to duty of care, we're going to come to it in due course about the incremental development as opposed to the three-stage test. But the three-stage test is reasonable foreseeability, legal proximity, and is it fair, just and reasonable? And as my Lord Burrows says, if you ground up, you just ask those three questions as opposed to necessarily saying it's reasonable foreseeability, shall I draw it back? But to be fair, from our perspective, we're very relaxed about whether or not the word control mechanisms is used, because we accept they are a control or break on the scope of liability, and that's right that they should be. So there's no issue between us and the respondent over the key role that legal proximity plays at a higher level of generality. The issue is to how it plays out with the application or refinement of the control mechanisms to the facts of these cases. And can I then turn to how legal proximity is established in Paul? So the core question has already been addressed. Is there legal proximity between the claimant and the defendant? Every secondary victim claim is attached to an event of injury, certainly leaving out the the type of case that I've identified earlier, the traumatic event external to primary and secondary victims, in which it happens a primary victim isn't injured, but that's a specific type of secondary victim claim. But in cases such as these, every secondary victim claim is attached to an event of injury. Words that are employed in Alcock, which I will take the court to later because this is an overview submission. This is the event which the claimant says was horrifying and caused her to suffer psychiatric illness, the damage which founds her claim. And see in Alcock, per Lord Ackner, if you kindly go to page 563. 563F. One of the control mechanisms, as this court knows, is shock. The means by which the psychiatric injury is induced has to be by shock. And Lord Ackner defines shock. He said, shock in the context of this cause of action involves the sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. That is, for our purposes, the event of injury to the primary victim. So that's how it works. If the secondary victim can establish that he or she has suffered a psychiatric injury by shock as a result of being the unwilling witness to the event of injury to the primary victim, and other control mechanisms are satisfied, such as a recognisable psychiatric illness, close ties of love and affection and so forth, then that claimant will qualify and be entitled to recover damages because that claimant is owed a duty of care directly by the defendant. And given that reasonable foreseeability has been established for the purposes of the appeal, it is to be taken as read that legal proximity between the defendant and the claimant is achieved if there is a sufficient connection between the defendant and the event of injury, which the claimant says was horrifying. That's because it's reasonable foreseeability has been established not vis-à-vis the event of injury, but vis-à-vis the claimant and the defendant. In other words, it's common ground for the purposes of the appeal that it was reasonably foreseeable that the claimant would be put as the unwilling witness to a shocking event. So if the shocking event is sufficiently connected to the defendant's breach of duty, then legal proximity will be established.
Just putting down a marker,
yes,
Lord Ackner does not define a horrifying event in that sentence. You say
yes, my Lord.
It's to be read as the event of injury.
Yes.
He doesn't say that.
My Lord, yes. I'm going to develop my submission. This is a sort of overview.
But I mean, using that as a springboard for your submission involves reading into what Lord Ackner said.
My Lord, I could go to Lord Oliver.
But you'll have to in due course.
I will go to Lord Oliver, my Lord, yes. Because there is no doubt that the event is the event of injury in this context. There is no doubt about it.
Well, I will make it good, my Lord. Resistance on that.
I will. I do hope not, my Lord.
And you'll need to explain, won't you, if you're not seeking to overturn Taylor and Novo, why the later death of the primary victim wasn't an event of injury. As I assume you're going to have to say.
I'm going to do very shortly. I'm going to tackle Taylor and Novo head on very shortly as part of the opening submission. Because these are issues.
Sorry, I missed that. It's about what? You just said Taylor and Novo is about.
I said I'm going to tackle it.
Oh, you're going to tackle it. Sorry, I just didn't hear.
Yes, sorry. Because it was bound to be of interest to the court to know at the earliest possible juncture. The test for legal proximity is that described by Lord Acton in his celebrated passage, which for reference purposes, page 924. That's the neighbour principle. Persons who are so closely and directly affected by my act that they ought reasonably to have them in my contemplation as being so affected when I'm directing my mind to the acts or omissions which are called in question. And that, I hope, addresses the observation of my Lord Briggs as to timing-wise, because you can see from that language that it's the contemplation of the defendant when he's directing his mind to the acts or omissions which are called in question. The breach. So returning to this case, the event of injury in this case, the cardiac arrest, was precisely what the doctors would or should have had in their minds as the adverse outcome they wished to protect the primary victim against. Cardiac arrest was the damage it was the defendant's duty to avoid. So in answer to the question, who should they have had in their contemplation? It's the primary victim suffering cardiac arrest and his close relatives witnessing and being shocked by this. The fact that the primary victim's cause of action accrued as a matter of law at an earlier date is nothing to the point. After all, the secondary victim proceeds on the basis of a direct duty of care owed by the defendant to the claimant. So breach is common, but damage doesn't have to be in that way. What matters is that there was something to witness. Here, the cardiac arrest was the first manifestation of injury caused by the respondent's negligence, i.e., the first witnessable event. And that draws very closely together the defendant's contemplation at the time of breach and the event of injury, which was the cardiac arrest.
Why do you focus on it being the first witnessable event? I mean, on this formulation, does it matter whether it was the second or the third?
My Lord, that's my very next submission, which is it's not so much that it's the first manifestation of injury, rather it is that on the full facts of this case, it is sufficiently clear that there was a close relationship between the appellant and the respondent, not least given the event of injury was the first manifestation of injury. And that involves the flexible application or refinement of the control mechanisms to this case, involving, as it does, delay between breach and event of injury. And it's certainly accorded with the sense of
injury there. You're still talking about the shocking event.
I'm talking about the event of injury, which is the cardiac arrest. That is the event of injury to the primary victim, which is witnessed by the secondary victim and directly causes them to suffer the psychiatric illness and was shocking. Certainly, the Court of Appeal's sense of where the justice of the position lay was all with the appellants. I'll just give you the reference. The Master of the Rolls at paragraph 80 at page 308, and Lord Justice Underhill at paragraph 103, page 313. Now, in answer to the question from my Lord Briggs, how this approach works more broadly, taking the same approach to other scenarios and going through Alcock, who should the Chief Constable have had in his contemplation as being affected if he permitted overcrowding to the pens? Answer, injury to those in the pens and shock to loved ones witnessing the event unfold. So the event of injury is of a piece with the actual overcrowding in the pens, which was a witnessable event causing witnessable injury.
So no duty owed to someone who was injured and died shockingly in hospital a week later.
Correct.
To the relatives of those.
Correct.
Why is that?
Because there is a need for legal proximity. Now, my learned friends for the other appellants, I believe, but I'll let them develop their submissions, go for as long as that event is shocking and factually caused. Why does the
doctor here owe a duty which the Chief Constable in Alcock doesn't?
It's about what's in the contemplation.
But why should it not have been in the contemplation of the Chief Constable that if people were crushed and badly injured, they might die in shocking circumstances in hospital a fortnight later?
Well, yes. In one sense, one can say anything is in contemplation, out with contemplation. One can simply say...
Well, I want you to address why you make the distinction.
Make the distinction, Lord, because we seek to recognise the importance of the guidance in Alcock which says you have to limit liability. You cannot have...
You're not talking about factual contemplation, you're talking about legal contemplation.
But
that's the difficulty, that these control mechanisms are all read back into these words which sound as if they're doing something factual, whereas they're not actually doing anything factual at all. What you're saying is, regardless of who factually might have been in his contemplation, only these people are allowed to recover. So those are the only people who are in his factual contemplation, but doesn't help to put it like that, or it doesn't help me.
Why does the policy of the law draw that distinction?
Can I just pause there and say, first of all, whether the court is minded as a consequence of observations and analysis to retract the law or to expand the law? If it's expanding law...
I just want to understand why you draw, why in your submissions this distinction is drawn in those two different fact situations.
Yes, my Lord.
It is a question of policy, as my lady says. It's not a question of what actually was in the mind of the Chief Constable or the doctor.
My Lord, it can be said to be an issue of policy. The reason I'm being careful in my response is because actually there is, it's legal policy, it's not public policy. It's actually, there's a comprehensible basis that works, which might be said, oh, let's look at the facts, but you are looking at the facts, because you're saying, what's in the contemplation of a doctor who's told, by the way, when you did that, you didn't actually diagnose and treat severe coronary artery disease. What's in the contemplation of the doctor is, should be held as a matter of law for the purpose of establishing a duty of care to be, that patient might die of a cardiac arrest. What's in the contemplation of an employer in relation to stacking of shelves, this is the Taylor and Novo scenario, what's in the contemplation is, if you don't stack them carefully, they might fall over and hurt someone. And if that's witnessed, then the person who witnesses might also suffer, in a shocking way, suffer a psychiatric illness and have a claim.
But if one asks the question in Lord Atkins' language, persons who are so closely and directly affected by my act that I ought reasonably, it's almost a sort of moral, social morality question.
Absolutely.
Why, and I'm repeating, I think, Lord Richards' question, why is the answer no to that in relation to someone who is badly injured by the immediate event but only dies in hospital a week later, surrounded by his family? Why is the answer no to that, but yes to those, if any family are there at the time of the initial event? What's so special about the initial event, which, ex hypothesi in this example, doesn't cause the person to die, and the death in hospital a week later?
Because if you're looking at, say, employer's liability, and you're saying what is it that's the event of injury, there is value in distinguishing between event of injury and consequence of injury. It's a point that the learned friend Mr. Maskery develops, and to some extent we accept that this is an important distinction point. It's an important distinction point because the policy of the law in this area has not been to say there shall be wholesale expansion of the law of secondary victims. And so at all stages I'm alive to that. The preliminary submission I was going to make was, of course, if the court wants to expand it, we sit behind that, and the learned friends carry the day, and we follow on behind. And nothing I would say I wish to
But you are seeking to expand it in this case. Certainly, as I see it from Alcock, we'll come to that. But at some point, I'd like you to try and address the question about the difference between the doctor in this case and the Chief Constable in that case.
My Lord, I'm hoping to do so, perhaps not successfully at this stage.
No, at some stage.
It may be that, I'm hoping I already have been developing it, my Lord. But your Lordship may feel...
I haven't yet quite got there.
I'm hoping I am, because what I'm trying to emphasise is take the employer or the Chief Constable, it doesn't matter. But if you ask this question, what should the Chief Constable have in mind? Of course, the Chief Constable will have in mind, by way of contemplation, a lot of things, because one can say you can contemplate your way through to ultimate consequences far down the road. But we're not allowing ourselves to do that, because that is the road to unlimited liability, and the guidance in Alcock is that's not the path to take. That's why we have control mechanisms. It may or may not be described as arbitrary. Some people may take views from a more academic perspective as to their validity, etc., but they exist, and I've got to work with them and not against them. So this is how to provide partial answers to these questions. But what at core is going on is, what is the damage which it's your duty to avoid? The Chief, constable's damage, which is his duty to avoid, is crushing in pens. And if that's witnessed, there's a problem. It's not. Having been crushed, a person suffers a brain injury. A day, a week, a month, 6 years later, they die in a dramatic way with a grand epileptic seizure. That is all a consequence as opposed to the event of injury. So it's a constant drawback to the event of injury.
But doesn't that create a problem for your case? Because I think you acknowledge, indeed the trial judge seems to have held, that the cause of action in negligence was complete very soon after the misdiagnosis, because that caused a treatable heart condition to get worse.
Yes, ma'am.
So that he was gravely injured and at risk of a spectacularly horrific death long before he actually had his heart attack.
Absolutely.
Now, why does the fact that the event of injury, if that's what event of injury means, went unnoticed by anybody, mean that you can jump over and base your claim on the consequential sudden death, whereas in another case where the event of injury is something which either the patient or others are aware of, you can't?
Because, my Lord, underlying all of this, and I will develop these submissions by reference to, for instance, the judgment of Lord Oliver, is the court's sense of producing a fair outcome. That lies at the heart, because one can see that one can be said to contemplate so much and say that so many things can be reasonably foreseeable. So these are tools in the court's armoury, but it's got to decide how to employ them. There hasn't been an analysis in Alcock of this particular issue. I don't respectfully say it's a development. I prefer application and refinement, but perhaps that's a language or semantic issue between. But in any event, it's certainly the application in a different context. And what one's trying to do is draw out the core guidance, especially in Alcock. Drawing it out reveals that what secondary victim claims are about and why it is that the court stepped in and fashioned this remedy in the first place is that the secondary victim is the unwilling witness to injury to another. And you are not an unwilling witness until the injury is witnessable. And it's witnessable in this case, the first manifestation of injury with the cardiac arrest. Were the position otherwise, then you would very artificially insulate the defendant who causes a silent breach and a silent accrual of cause of action.
Well, would it make a difference if in your case, the primary victim had had a severe bout of angina a few months before, and so the injury had manifested itself, and then this cardiac arrest occurred a few months later? Why should that be decisive as to whether you can recover?
It may not be, my Lord, and that's why I sought to set out just earlier, when I made a submission, that it's not so much to test his first manifestation of injury, it's a flexible test, where you have to look at the combination of circumstances. That was Lord Oliver. Look at the combination of circumstances to decide whether in that case there was a sufficiently close relationship. And this is, for the avoidance of any doubt, a path already gone down by the Court of Appeal. There is Court of Appeal authority, Walters and North Glamorgan, in which the event of injury was not the first consequence of the breach of duty.
I thought you'd accepted that in Walters the Court of Appeal didn't face up to the problems which exist in this case in terms of defining the duty.
I readily accepted that the issue which is before this court today was not put against me in Walters. But the case in Walters and the case in Renane in the Court of Appeal, after Taylor and Novo, both cases proceed on the basis that it is not a basis for knocking out either case, but there have been what I'm going to loosely call grumbling symptoms in the intervening period, because it is for, and I will develop these submissions, the good sense of the judge to determine whether focusing on the event of injury identified by the claimant allows the court to, using the language of Lord Oliver, divine that there is a sufficiently close relationship between claimant and defendant, that the business of legal proximity is satisfied on that case. So that is a flexible test designed to achieve justice as opposed to a completely arbitrary lacuna in the law which would otherwise operate.
Are you trying to develop, in effect, a special rule for doctors?
No, my lord, because you can have...
What I'd be interested in is examples where what you say applies in these cases would apply in quite different factual circumstances, not involving clinical negligence.
Yes, my lord. We give the,
some stage.
Well, we give the example, my lord, in our written case of a poisoner. A poisoner, my lord.
Poisoner?
Poisoner. You can poison somebody. You don't have to poison someone deliberately. It could be a dramatic case with deliberate, but then we might be in a different world of battery or some such. But you can poison someone carelessly, and you can give them a poison that they instantly froth at the mouth and fall over. You can give them a poison which has no effect for 6 weeks. You can give them a poison that has...
I see, and then they're taken into hospital and their families around them and they die.
May not be in hospital,
well, no.
That's a non-clinical negligence case.
So I suppose concussion might be an example, might it?
No,
you're injured by falling something or other, it's the defendant's fault, and then a day later you drop down dead as a result.
My lord, I wouldn't go so far because the line we accept is drawn in that context is there you have a witnessable event. To get concussion, unless you got concussion by, I don't know, a sort of oral shock or something.
No, I mean concussion, as we know, can occur. You have no immediate obvious symptom, but the injury and even death can occur sometime, some considerable time later.
Well, my lord, if on the facts, I mean, one would ask the question, how does that concussion occur? Because
you're hit on the head.
Well, then you're hit on the head. It's a witnessable event.
Yes, but you don't suffer the consequences of that in terms of death caused by concussion until a day later, witnessed by your wife, who was not there when you were hit on the head.
My lord, I would respectfully invite the court to adopt a different... I'm not going to attach myself to the hit on the head case, but I would attach myself, for instance, you could probably have an oral shock. You could have a sound wave that's sent through and that gives someone some form of brain damage, which is completely silent because it happened, no one knew there was this shock wave that had gone through, nothing visible. It's the silence. It's the non-witnessable silent breach and accrual of cause of action that's key.
And then you suffer a horrific result, which is witnessed by your partner.
My lord, yes, but it's actually when it's result, it's not result consequence, because actually, if you're asking yourself the question, going back to this case on these facts, what should a doctor have in contemplation as the outcome of not treating significant coronary artery disease? It's cardiac arrest. That's why you treat it, because people die from it, and the paradigm way of dying from significant coronary artery disease is cardiac arrest.
I appreciate that.
It really is the damage.
But equally, if you drop something on someone's head, then concussion is a reasonably foreseeable result.
Absolutely.
So where's the difference?
Well, there is a difference, because that is a description of a witnessable event. It is not a silent event.
I'm taking that the witness was not there when the victim was hit on the head. The secondary victim, the witness, was there when the concussion manifested.
Lord, each case would have to be determined on its facts. I think because of the issue I have in my head in relation to how this concussion occurs, which has caused me difficulties in responding. But the test which we are advocating to the court respectfully is a flexible test in which the court would make this assessment. And when we go to...
sorry, if I may just pick you up on that, because you said several times now flexible test, but surely the court needs some principle to apply in order to determine how that flexibility should work through in practice.
Absolutely.
And I think that's what we're asking you about.
And I keep coming back to saying what is, if I can put it this way, convincing to me, if not to the court, which is that when you ask the question, what should a defendant have in contemplation, the employer for RACS is someone being hurt when a RACS falls over, but the doctor responsible for a patient's underlying condition is the outcome of an untreated condition, and the adverse outcome is cardiac arrest.
Well, so that does tend to suggest you're asking for a particular rule for doctors.
My Lord, my answer to that was the same by relation to the poison, where the poison has no effect for 6 weeks.
All right, but why does it make a difference that it's a silent event? I can't quite see the difference between your oral shock resulting in injury 24 hours later and someone being injured in a rugby match and suffering the results of concussion 24 hours later. What's the essential difference in terms of legal policy between the two?
Well, in one sense, I don't wish to argue against myself, as I could say, oh, well, I'd embrace all of these. This is terrific, but I'm very cautious about doing so. Each case would, the difficulty with examples is each case would have to be analysed incredibly carefully on its facts to understand how, when you then seek to answer that question, what should have been in the contemplation of the defendant in the rugby match or whatever else it is, what should have been in their contemplation at the time of their breach of duty in relation to an event of injury which prior to that time was silent. I mean, that's the scenario we're looking at. So I keep going back to it's a flexible test. That does provide completely rational basis for that analysis, because we are not simply free floating into any event of injury, any subsequent event of injury. We'll pick an injury 3 years later with the 4th epileptic seizure or whatever. We're not in that world. We're looking at what that defendant should have had in contemplation at the time of the breach.
And I think what we're pressing you on at the moment is the significance you attach to the witnessability of whatever the event is. Just if I may, to go back to Lord Richard's concussion example.
Yes, please.
I mean, suppose someone receives a blow on the head, but no one at the time, and that's delivered negligently, but no one at the time thinks it's very serious. They say, ow, get back up, continue with life as normal. But in fact, there is an underlying concussion there, and that's going to lead to death in 2 or 3 days' time. Why, you seem to be saying, well, the very fact that the blow was witnessable, whether witnessed or not, puts it into a different category of case where one doesn't look at the later consequence.
Yes.
But why?
Why? Because one's seeking a just and fair outcome. The law in relation to secondary victims has developed. Forgive me for this is a repetition of the answers I sought to give earlier. The law is in relation to secondary victims has arisen to provide a remedy where the court considered that one should be provided when a close family member witnesses an event of injury. So you need something which is witnessable.
Yes, but the claimant's son or husband or whatever dying suddenly is witnessable. It is witnessed by as a result of the concussion.
Absolutely.
Is witnessed by their mother, wife, husband, whatever it may be.
So is the epileptic seizure 20 years later, but it's very unlikely that the court would consider that was an event of injury for the purposes of secondary victim successful claims.
But why?
Well, my Lord, can I not row against what the case that I believe is going to be promoted by the appellants, because it's a slightly it's an environment in which my learned friend Mr. Maskew may think this is tremendous. He's sort of working up some of my arguments for me, but I am promoting a case.
You draw a distinction, let me get it absolutely right, between a silent event
Yes, my Lord.
and a witnessable event.
Yes, my Lord.
And in the case of a silent event, then the subsequent event of injury, if witnessed, can give rise to a claim.
Yes, my Lord.
But where there is a witnessable event, however minor at the time,
Yes, my
the
Lord.
subsequent injury, however serious, does not give rise to a witnessable claim. Now, you're drawing that distinction.
Broadly, with caveats, because, as I say, on the facts of a given case, there's interesting scenario raised about the
Yes.
concussion and just whether it is witnessable or, in fact, a silent injury completely, because it's like the oral shock, no one even knows, gives rise to its own series of questions which are not before this court. But yes, ma'am.
Right, thank you.
It seems to me your difficulty, arises because you're identifying the event as an injury. Once you do that, then you've got no ability really to distinguish one injury from another.
Well, you do.
But the distinction in the cases is between the accident and then injuries which may be later consequences of the accident. And the problem that you have is that there's no accident here, so you have to focus on the injury itself as being the event.
No, respectfully, not at all. It's not the guidance of Lord Oliver. The guidance of Lord Oliver is to focus on the event of injury.
But it's that has to be shocking over and above the fact of the person's death.
Yeah, I think I understand the question, and if I answer it in this way, the injury to the event of injury to the primary victim has itself to be shocking. In other words, merely dying peacefully and the fact of death, the person has died peacefully, does not suffice. This is a by shock cause of action.
Yes, but the difficulty is that the way these cases come before the court is on a strikeout, where you have to assume, for the purposes of the application, that the family member has suffered psychiatric injury of a recoverable kind.
Yes, my lady.
But one can't then argue back from that assumed fact also to assume, well then, the event must have been a shocking event because we're assuming that they've suffered shock from it. But there has to be some threshold, independently of the assumption made in all these applications that the claimant has suffered psychiatric injury, that it's a particular kind of event, which, because the way these cases come before the court, that has to raise the possibility that yes, this person may have suffered psychiatric injury from witnessing it, but it's not a sufficiently shocking event to give rise to a cause of action.
Absolutely. That's an additional requirement. It's a part of the control mechanisms. In Walters, Lord Justice Ward says the requirement of shock is part of the control mechanisms.
And you say, well, the shocking event can be the event of injury rather than some fire or crash.
Not just can be, my lady. I mean, it's absolutely apparent in the passages I'm going to take the court to.
You say dying of natural causes can be the relevant event.
Dying, I take care because I think your lordship is indicating that a cardiac arrest is dying by natural causes.
Yes,
that's I think where your lordship's coming from. If the cardiac arrest is shocking, as that term is understood in the law of secondary victims, absolutely.
And negligently caused.
Oh, with all the other steps in the process.
I was going to ask this question, very similar to what Lady Rose has said, that this distinction between silent and witnessable strikes me, at least at this stage, as less significant than the additional requirement that has still to be fed in, which is that this is a horrifying and shocking injury. And that is why some of the examples given, the shocking and horrible event at Hillsborough was actually not the way in which people might have died, it was the crushing. And that is surely the distinction between the person who is crushed at Hillsborough and then several weeks later dies, and as a result of that death, the relatives suffer psychiatric illness, because the actual death is not the horrific and shocking event.
Correct.
But it doesn't mean that you can't have the event being a shocking and horrific injury.
Well, that is exactly the position which I'm going to seek to develop. The respondent position is there can only be recovery if there is an event, traumatic event, external to the primary and secondary victims. Our cases, that is a different category of case. That's why I open my submission saying that's Alcock. That's the facts of Alcock. But there is an entire world that Lord Oliver absolutely homes in on. This is not a ninthly point in response to the observation of the Lord Legate at all. This is central to the analysis of Lord Oliver, in which there's no requirement for anything to be external to the primary victim, but the control mechanisms are very effective, because see the observations from Lady Rose, there needs to be not just injury to the primary victim, but injury in shocking, in a horrifying way.
Have we reached the point where we should look at Alcock? Because there are constant references to what Lord Oliver says without us actually having yet looked at it, and it seems to be central to what I was looking to see your programme, as it were, and I suspect we're moving into your third.
No, we haven't all looked at Alcock, Mr. Weir, but
Yes.
you can guide us through it.
Of course I will.
And after a short break, I think, because we're up to the sort of halfway point of the morning, if that's all right with you.
Of course I will.
5 minutes or so.
Please the court. I had intended next to move to how the application or refinement of the control mechanisms calls for flexibility so as to achieve justice, but I have a feeling I should park that and come back to it so as to get to my submissions on there's no requirement for an event external to the primary victim, which brings out the event of injury passages. So I'll come back, I know, to that earlier submission later. This is in response, just so the court understands, to the respondent's case, which is that it needs to be a traumatic event external to the primary victim. In the nature it's described of an accident or a violent happening. I'll just give you the reference, because no doubt my learned friend Mr. Maskey will develop all of this. It's paragraph 65C at page 269, which it also would appear has to include the breach of duty. See paragraph 30 at page 261 and paragraph 59 at page 267. At 261 it said proximity exists where the claimant witnesses the breach and immediate risk of injury. That's how it's put at page 261 para 30. At page 267 they say the event is not simply the eventual consequence of the breach, but has to have had the character of an accident, or at the very least to be an event that encompasses a breach and consequence, which then gives rise to psychiatric injury. That's a very hard line approach, which is now being adopted by the respondents, which seems to involve witnessing breach and traumatic event external to primary victim in order to hope to qualify. And in short order, our response to that is that there are cases like Alcock in which the injury may be linked to a traumatic event external to the primary victim. You also have classically a fire or an explosion, and the second victim witnesses the fire or explosion as opposed to the primary victim jumping out of a window, and is very anxious for the safety of his or her loved one in the building, whether or not subsequently injured. But the scope of secondary victim claims is not so limited. In cases such as this one involving a silent breach of duty, delay, and a later manifestation of injury, our submission is that the claimant needs to prove that there was an event of injury Secondly, there is no requirement for the claimant to establish presence at the breach of duty. Thirdly, the event of injury must have been horrifying, such as to cause the claimant psychiatric injury. See the observations from Lady Rose in relation to that. Fourthly, there is no requirement for the event of injury to be external to the primary victim. Were the position otherwise, there would be an unjustified carve-out for all those cases in which the defendant's breach of duty impacts directly upon the primary victim without an intervening event external to the primary victim. So can I take the first two of those submissions together, which is the claimant needs to prove that there was an event of injury, but not that the event includes the defendant's breach of duty. Can I start with McLaughlin, please, at page 598. In the judgment of Wilberforce, 598b. 598b, at the beginning of that paragraph, you can see that Lord Wilberforce says, in doing so, we must bear in mind that cases of nervous shock and the possibility of claiming damages for it are not necessarily confined to those arising out of accidents on public roads. Of course, he mentions accidents on public roads because all the cases, including McLaughlin to that date, involved accidents on public roads.
Somewhere in your case, I think you suggest that he's saying that it doesn't have to have an accident, but it seems to me you can't read that into it. He's saying it doesn't have to be a road traffic accident.
Well, my lord, it rather depends on how one uses the word accident. One can describe our case as a medical accident case.
Well, he goes on to say, to state therefore a rule that recoverable damages must be confined to persons on or near the highway is to state not a principle in itself and so on. So he's clearly talking about saying it's not, this isn't confined to road accidents.
Absolutely, my lord. And I'm just coming on to that, just to follow through that sentence. He says, of a more general rule, this is the part I then wanted to read out, a general rule that recoverable damages must be confined to those within sight and sound of an event caused by negligence, or at least to those in close or very close proximity to such a situation. And the reference to negligence in that context is a reference to the defendant's breach of duty. And later at 599D, Lord Wilberforce says, as regards proximity to the accident, which is unsurprising because he is considering the case of a road traffic accident, it's obvious that this must be close in time and space. It is, after all, the fact and consequence of the defendant's negligence that must be proved to have caused the nervous shock. I wanted to take you to this passage because this is a passage which the respondent attaches great weight to. See how Lord Wilberforce says the fact and consequence. In response, that is a sentence about causation. See the sentence. It is, after all, the fact and consequence of the defendant's negligence it must be proved to have caused the nervous shock. And of course the breach must have caused the nervous shock. It doesn't therefore shed light on what constitutes the relevant event. And see here the analysis of Mr. Justice Chamberlain below at paragraph 68 at page 342. So page 342, para 68, I'd referenced the part in which Mr. Justice Chamberlain confirms that reasonable foreseeability is established for the purposes of the strikeouts, and he then, as the court sees, says it is true as Mr. Bagot submitted in Lord Wilberforce's formulation. So Lordships and Ladyships see that passage. You can just read it down to the end of 68, please. And then turning to Walcott, Lord Oliver repeatedly homes in on the injury to the primary victim as being the event which must trigger the claimant's psychiatric illness. And can we go first, please, to page 569? 569. At E. We're picking it up between D and E, if the court has this. I'm at 569. In D and E, broadly they divide into two categories. That is to say, those cases in which the injured plaintiff was involved, either immediately or immediately as a participant, and pausing there, i.e. a primary victim, and those in which the plaintiff was no more than the passive and unwilling witness of injury caused to others. This is right at the beginning. This is Lord Oliver, right at the beginning of his judgment, getting to it in relation to what secondary victim claims are all about. 572H. 572H, please. It's a passage I've read out earlier to explain that he was leading to his proximity from a combination of circumstances, but I now need to go back to the exact wording. So at H, that paragraph, what is more difficult to account for is why, when the law in general declines to extend the area of compensation to those whose injury arises only from circumstances of their relationship to the primary victim, an exception has arisen in those cases in which the event of injury to the primary victim has been actually witnessed by the plaintiff, and the injury claimed is established as stemming from that fact.
Sorry, can you just give me the page? I've just
572H.
But he goes on that such an exception exists is now too well established to be called in question.
Yes, my lord.
So what is it that has been established to date? I mean, they're all cases, aren't they, of witnessing the accident, not simply the injury.
McLaughlin is a case of witnessing the injury only.
Well, just
come upon the aftermath and witness the injury.
Fair enough.
And, my lord, this is why, perhaps with an excess of brio, I was resolute in indicating that 563, Lord Ackner is referring to the event of injury, because when you tie the two together, you'll see how Lord Oliver says the event of injury to the primary victim, which has been actually witnessed by the claimant, and the injury claimed is established as stemming from that fact. In other words, that has to be the horrifying event of injury.
Yes.
That's how the system works.
Yes.
Well, the injury he's talking about in the second clause is the injury, the psychiatric injury to the secondary.
My lady, I'm not sure where your ladyship is, forgive me.
Where at H.
No, it says event of injury to the primary victim.
Yes,
to the primary victim.
By the plaintiff, and the injury claimed.
Absolutely. The secondary. Absolutely, yes. The event of injury to the primary victim, if it's the event of injury is shocking and gives rise to a recognisable psychiatric illness because it is witnessed by the secondary victim, is how the control mechanisms operate, and they operate very effectively to control the scope of liability, but also to provide for liability. And then if the court kindly goes over the page to 573, starting at F, this is the passage which is often treated as this is the law, but it's not this is the law. It's a passage that says the common features of all the reported cases of this type decided in the country prior to the decision of Mr. Justice Hidden.
Well, he's not just reciting where the law has reached, you see, because at H he says it must, I think, be from these elements that the essential requirement of proximity is to be deduced. So he's not just reciting what the courts have previously decided. No. He is actually saying these are the control mechanisms.
No, my lord, he's a mixed...
You don't think so?
Well, it's not a question of thinking, my lord, it's a question of, if you look at the first one, he says first that in each case there was a marital or parental relationship between...
Now, what are you saying? Are you saying these are not the necessary elements to finding proximity?
No, my lord, I'm simply seeking to...
No, are you saying, forgive me, I don't quite understand. Are you just saying that these are Lord Oliver looking at previous cases and saying what they've decided, but he is now going to decide something different?
I am seeking to show that Lord Oliver is there setting out. If you look at the first example, he says, first, that in each case there was a marital or parental relationship between the plaintiff and primary victim. And part of the ratio of the case of Alcock is that you don't need to be a parent or in a marital relationship.
Yeah.
And that's why one has to take a little bit of care. That's all I'm saying. I'm not seeking otherwise simply wholesale to downgrade. But when one looks at it and sees reference to accident, it all comes under a heading, the cases until now, which have involved only accidents, by which we mean road accidents. That's all I'm seeking to say, giving it its full and proper context. So anyway, my Lord, going then to the fourth one at G, does the court see, and fourthly, that the injury arose from witnessing the death of, extreme danger to, or injury and discomfort suffered by the primary victim. And that is why I was emphatic, respectfully, in rejecting the observation that they're all about accidents. They're not all about accidents. It's about the event of injury per Lord Oliver.
But what about the third one?
My Lord, I see that, and that's why I've sought to explain that this is a recitation of the position in relation to the cases up to that time, which involved accidents. The distinction didn't need to be drawn when you have an accident, because you have everything occurring at the same time. You have the careless driving, the breach.
I'm sorry, in yes. Alcock, isn't the third element very much in play?
Yes, they're all in play, my Lord.
I mean, you're right, of course, in the point you make about the first element, that was changed, modified by this decision. But were not each of the others in play essential parts of the decision?
Absolutely in play in relation to Alcock, as they were in play in relation to the previous accidents, because Alcock is like the previous accidents. It's a case in which, this was my submission right at the beginning this morning, Alcock is a case involving a traumatic event external to the primary victim.
Can you extract from Alcock that the third element is not a critical, essential element?
Well, forgive me, but I hope to have made that submission. I've just made this,
there's nothing in Alcock that suggests that the third element isn't essential.
No, my Lord, I don't put it that way. That's...
No, I know you don't. I'm putting it to you. No, why do you say... I'm sorry,
yes, my Lord.
Mr. Wee, I'm just not following the way you're putting
my
it
Lord,
at the moment.
In any case, the House of Lords or Supreme Court has quite a lot to grapple with when these cases of, major points of law come before it. It's always grappling with these points of law in the context of the facts which are before it. And some of the language which is going to be employed is inevitably going to reflect that. And when you are only in a world to date, in Alcock, of traumatic events external to the primary and secondary victims, there will be an interchange at times between accident and event of injury, which will be commonplace, and we see it between the third and fourth.
Well, I think the thing is we have to accept that the point we're now considering wasn't in focus there, and therefore focusing on the particular language
exactly
isn't going to take us terribly far. And I think that works both ways round.
No, it doesn't work both ways round.
I mean, you want to pick out every time it refers to injury, and then say whenever it's accident, well, that was the context of the case, but it's all in the context of the case.
That's not sauce for the goose, it's sauce for the gander at all, my Lord. I've taken you to those passages. There's one more at 578, which is at E, in which Lord Oliver explains, in every case, the underlying essential postulate is a relationship of proximity in plaintiff and defendant. It's this, as it seems to me, which must be a determining factor in the instant appeals. No case prior to hearing before Mr. Justice Hidden from which these appeals arise is countenance award of damages for injuries suffered where there was not at the time of the event a degree of physical propinquity between the plaintiff and the event caused by the defendant's breach of duty to the primary victim. It's a theme that runs through it. I'm not cherry-picking. This is the guidance. The core guidance is event of injury.
But I mean, isn't that harking back to what he'd already said at page 573, where he focused on the case law prior to the decision of Mr. Justice Hidden and made the points that Lord Richards pointed to?
Yes, and my Lord,
and has indicated that they give rise to the elements that need to be satisfied for a relationship of proximity.
My Lord, the submission I'm making is that even in the context of the accident cases up until that time, the focus of Lord Oliver is entirely clear. His focus is on the event of injury caused by the defendant's breach of duty.
You've said that, but this paragraph seems to me to suggest otherwise. I mean, he's talking here about physical and temporal propinquity to the event or its immediate aftermath. We know what he means by immediate aftermath, because that's McLaughlin.
Yes, my Lord.
I'm just having difficulty in accepting your submission that he's just talking about the injury and not also talking about the accident.
My Lord, there's event caused by the defendant's breach of duty. That deals with
well, the event, we know what that was at Hillsborough. It wasn't just the injury.
My Lord, absolutely that in the context of that case, this was a distinction that didn't need to be drawn. But it could be that the guidance of Lord Oliver was all of a piece and said you need to have an event external to the primary victims, which event is shocking. And it is absolutely not what Lord Oliver has said, because what he has said repeatedly in the passages to which I've now taken to court is that he is concerned with the plaintiff being an unwilling witness of the event of injury to the primary victim. And that absolutely goes to the core
of your submission.
Never a promising observation, by the way. Put it in those terms.
Well, it's quite clear it's not the witnessing of the breach of duty.
Quite
that can't be doubted. The question, I think, is whether there is between the breach of duty and the injury something that is being classified as an external event.
Which is surely the more natural, if you're going to focus on the language. He doesn't talk about injury, he's envisaging an event, which is something you see as in what happened in Hillsborough. I mean, I don't think this case answers your question, but to claim it as authority in your favour does seem to me an arch exercise in cherry-picking.
I'm sorry, I did miss that last bit.
To claim this as an authority favouring your position that the injury is all that matters and not there doesn't need to be an accident seems to me really to be an exercise in cherry-picking bits of the language and leaving out others.
It's the event of injury which must be shocking. That's the point. And if you have an external traumatic, external to the primary victim's event, then you're in that category. If you don't, and the paradigm is clinical negligence where you simply affect the primary victim directly, you are still looking for this very same thing, which is the shocking event of injury to the primary victim being witnessed by the secondary victim. And that, respectfully, is not cherry-picking, but it won't assist me to
But some of the accidents which have given rise to liability to secondary claimants didn't cause any injury to the putative primary claimant at all.
Yes, ma'am.
So that it was the accident giving rise to an apprehension that he might be injured rather than his injury.
Absolutely. And I've sought to set out already, earlier, how that is, if you like, a category of case, a different scenario. You can have that scenario. And we sought to set it out in our written case. You can have a fire that's burning and one person is in fear for a relative they believe to be in. You can then have someone jump out of the window and another person witnesses the person jumping out, and you can then have someone come into the aftermath, the immediate aftermath of that. So there is this inherent flexibility, and it's on submissions I haven't yet made within the system, but it's looking for the same core element. That's the point.
But you have to, those cases where there is no injury and hence no event of injury, you have to treat those as a sort of a little extra
sui generis category.
Yes.
Yes,
Or are you saying that there can be that either an event which does or doesn't, an external event which does or doesn't lead to injury, or an event of injury can be enough?
yes, the latter. Absolutely.
So we hive off the so-called imperilment cases because they clearly do rest on an imperiling event and there is no injury on the facts to the primary victim.
My Lord, yes, and it's why, again, very careful language by Lord Oliver, who identifies that there are different types of case, ones in which the primary victim has been injured, ones in which there is a fear in relation to it's 573G, injury suffered or from witness and death of extreme danger to, or injury and discomfort. I'm at 573G, suffered by the primary victim. Because none of this should come as a surprise or should be a difficulty to the court, because the court is ultimately concerned with the justice of the position. That's the point. Well, I understand.
Well, that doesn't get you very far, Mr. Weir, because different people can have different ideas of the justice of the position.
Well, I mean, we're also carving out a form of nervous shock caused psychiatric illness from the vast range of other types of psychiatric illness that may be equally caused by negligence, but for which we all accept, however unjustly, the law affords no remedy. So we're making a policy decision as to where to draw a line, rather than simply engaging in an exercise of abstract justice.
Of course, my Lord. My point is rather that the courts have gone there because they understood the justice situation. So this court shouldn't be concerned and say, oh, how come there are two elements to this? Because the courts have determined as an issue of fairness and justice that there should be. So I'm not dealing with prospective analysis. I'm dealing with this is what the courts have done. This court should not be concerned that it's done it because it wanted to fashion a fair remedy. That's the point. When you walk through the history of the cases, you see the courts repeatedly testing themselves, should we fashion a remedy? And these are steps that have been taken. That's my point.
Can I ask you this? I mean, just going back to Hillsborough, I mean, it looks to me as if Lord Oliver might be interpreted in more than one way. But I'm just trying to pinpoint what the event might be if it wasn't the injury. So I'm assuming that it's the crushing in the pens that is the event if it's not the injury. So let's just assume that we've got people who are being crushed in the pens but actually are never injured.
Well, they may be injured, some of them.
Okay. We then get relatives who see the crushing in the pens, but the person isn't injured, so we're in the imperilment type scenario. Then let's take the relative who isn't at the match, so doesn't see the event of crushing in the pens, but comes along to the mortuary afterwards, or the makeshift mortuary, and sees effectively their loved one lying and now dead, and suffers as a result of that psychiatric illness. Now, one might say, well, that's recoverable because it's the immediate aftermath. But is the event, the crushing in the pens, or the death in that situation?
That would be the death. That's why, as I say, in that fire and explosion example, you can have different claimants recover on different bases, because on order bases, and it may sound like a roll-out trite statement, say it's fair and just to you, but not to me, and so forth. I do understand that, but actually it's really important because it's what's lying beneath all of this, and the courts have gone there already.
But is there any case in which there's an event of the Hillsborough type not witnessed by the family, which then leads to the horrifying death of the primary victim 10 days later, which is witnessed by the family, where the family actually recovers?
No, I don't know.
I mean, you say it's the death, but if you were right, then the family that witnessed the death a week later ought in principle to recover. But as I understand it, that isn't what the cases have established, and indeed some claimants have failed despite satisfying that fact set. I think the second of the Hillsborough cases is one.
Yes, I suppose it could be said, essentially that's the Taylor and Novo scenario.
Yeah.
Yes.
Which I think you seek to defend.
I think accept.
If that's right,
Accept.
why is it that, in answer to my Lord's question, that death
Yes,
rather than the crushing, which is the relevant event?
I see that. And when there is a traumatic event external to the primary and secondary victims, and you have a witnessable event, and you either witness it or you come across its immediate aftermath, and that would probably be the proper foundation analysis for the foundation of recovery in those cases. When you don't have an event external to the primary victim, you either draw up the bridge and you say, well, there we are, I've got no event external to the primary victim, I'm going to close down a line of Court of Appeal and High Court authorities which have provided a remedy in this situation. And when you're thinking, should I do that? This is when I go back to the flexible tests that I haven't yet developed, which is absolutely, again, apparent in the guidance, because I would be asking the question, why would you be so motivated to do that? And although fairness and justice is one person's poison is another man's something else, it doesn't matter, because you have to grapple with that. And it's your sense, your collective sense of fairness and justice, which carries the day. But you have to engage with that. You can't say, well, fairness and justice is a bit opaque or open-ended. I'm not going to address it. You absolutely have to embrace it.
But I think your case, as I understood it, was that this death was an event of injury which was shocking above and beyond the death, because Mr. Paul collapsed in the street and hit his head, whereas I think you would say that a different situation, which you don't have to say is covered, would be if he had had the heart attack in his chair at night or in the afternoon when the children were playing in the same room.
You can have them while asleep. Absolutely. No, that's an additional requirement, exactly as per the observation of Lady Rose, that the event of injury has to be shocking. So we don't say there's no need for a shocking event. And it's not shocking just to say someone's died. The way these cases work in real terms is the psychiatric report. If the psychiatric report on analysis is actually saying the fact of the loss of my loved one has caused my injury, you have no claim. It's not the fact of loss. It's the experience that you unwillingly witnessed of the shocking or horrifying manner in which the injury occurred, the cause of your injury. And classically that would be post-traumatic stress disorder, because it would be the trauma of witnessing that experience.
So just coming back to my Lord Briggs's example, it may depend, might it, on your analysis, whether the death 2 weeks later was itself a horrifying and shocking death.
On the Lord Briggs
My recollection is that it was, but that didn't.
On the Lord Briggs example, I've conceded that there's the external to the primary victim traumatic event that's witnessable, and so that's the relevant event. In the world of no external to primary victim cases, then you're looking for the event of injury, because there's no external traumatic event, and there, that event of injury has to be shocking. I hope that's clear.
It's a difficult line to draw in terms of justice and fairness, isn't it? I mean, if you're the family of the individual who has been injured at Hillsborough, but you weren't there, and 2 weeks later you are there when that individual dies in shocking circumstances, to say, well, Hillsborough had happened and there were witnesses there and therefore you can't recover, but the claimant in this case can. That's a difficult line to draw.
My Lord, that's a return to the theme which was articulated so clearly by Lords Hoffman and Steyn in the White and Chief Constable case, in which references to the thus far and no further patchwork quilt.
I suppose what I'm really asking is, why do you say that it's fair in one case but not the other?
Well, why do you need to say this at all?
Precisely. I start from.
Take the questions in turn, Mr. Whip.
I start from a different position, my lord. I look at the basis upon which recovery is said to be workable, and I seek to apply that in a different situation. That's how I do it. So that's the consistency. It will always be possible. This is the point. It will always be possible to say, oh well, why is it that someone claims in the immediate aftermath but not the aftermath? So let's keep it as simple as possible. Let's just say road accident, turn up within 1 to 2 hours. This is McLaughlin, recover. Turn up in 3 to 4 hours. Outside immediate aftermath, don't recover. My point is, do you say from that, oh, why is there an immediate aftermath doctrine? No, you don't.
Just please come back to these two events rather than, if you wouldn't mind, just so that I know why you say
yes, my lord,
it's just in one case but not in the other.
Yes, my lord, because I think your lordship was seeking to compare or contrast the Paul case, which should it be successful, with a case in which
I suppose
there's
the
an external traumatic event and someone comes outside the immediate aftermath.
Yes.
So we're comparing, if you like, apples and pears, which is not helpful. This is the point I'm trying to make. If you're in the external traumatic event, you have a witnessable event. The courts have then deemed it appropriate to extend that to the immediate aftermath. In any case beyond that, you can always say, well, why not me too?
I see.
But that's not an answer, because the courts have gone for the immediate aftermath. If you then address the issue of a case in which there is no traumatic event external to the primary victim, you're now in a different scenario in which you either say, ergo, no claim for secondary victims, which I seek to show this court today is unsustainable because it is inconsistent with the invitation and guidance of the courts before you to apply the rules fairly and not mechanistically and not to withdraw, but to make incremental developments as are appropriate. So that's simply not the right answer. You then have to say, right, what do I do with the guidance that I see in Alcock? And I am not seeking to cherry pick the guidance in Alcock. What do I do with this guidance when I seek to apply it in this different context? It can be applied, and it can be applied in a way which is sufficiently limited as not to lead to the spectre of unlimited liability, which is what lies behind a lot of this, which is, hold on, you're now going to allow for everyone. No, I'm not. Because we have not just the constraints that we understand, injury by shock and so forth, but because we go back to the submissions which we've made about how you identify the event of injury in the context of a defendant who only injures the primary victim directly, not through the mechanism of an external event to the primary victim. And in that context, you're looking at what's in their reasonable contemplation, and that's where the court then goes. And we've already sought to draw out our submission in relation to that. That when you ask what would a doctor have in his reasonable or her reasonable contemplation if he failed to diagnose a serious coronary artery disease, it's cardiac arrest. And that is an entirely defensible, supportable and fair and rational basis upon which to approach matters. Otherwise, you engage in a carve-out, and carve-outs are not to be encouraged.
He has to contemplate, he or she has to contemplate that it's going to be a cardiac arrest not in the person's sleep, or might be a cardiac arrest not in the
Lady, that's all part of the reasonable foreseeability. The reasonable foreseeability test has been passed in this case, so we move on from that. That's because you always look at these cases, as I say, with the benefit of hindsight, as opposed to simply prospectively with a whole menu of medical outcomes. You don't. And this is a paradigm medical outcome for serious coronary artery disease.
At the moment, it seems to me to be a big step to go beyond cases of disasters like Hillsborough or witnessing horrible road traffic accidents, to say that if you see someone die of a heart attack, that brings you within the category.
My Lord, it's not a big step, and it's a step which one of your Lordship's predecessors, Lord Clark, as Lord Justice Clark, felt very prepared to take, along with Lord Justice Ward in Walters, It's a path that has been crossed.
Well, that's the case at the moment that I have great difficulty with, but you'll be coming to it in due course.
The high watermark of your case on that aspect of the matter is the two cases where you show that this court or its predecessor approved Walters, which you started with, I think. Because, I mean, we probably need to get to Walters at some stage, but,
of course,
but Walters is a pretty, upholding Walters, if you like, is a pretty important plank in your case.
Well, my Lord, yes, it's upholding Walters, but it's also simply this court respecting the development of the incremental development of the law over the last 20 years. So it's not just upholding Walters. We seek to uphold all of the case law that has been established. These are difficult issues. The whole point is courts have been grappling with them. So it doesn't merit, respectfully, a sort of sledgehammer response from the highest court. It more merits a recognition of the careful, reasoned and incremental development of the law over the last many years in the light of Alcock.
Well, it doesn't mean that when we've got dicta and decisions pointing in different directions, we have to try and come up with some unsatisfactory theory which somehow accommodates them all.
My Lord, in terms of dicta and dicta that go the other direction, apart from Taylor and Somerset, which was and the dicta supporting it by Lord Dyson, Taylor and Novo, it's actually one direction. That's the submission I'm making. It's all in one direction. And the direction is a flexible, not a mechanistic or rigid approach to the development of the control mechanisms to meet the justice of cases. And that's what the courts have been doing. And we would respectfully invite this court to take great care before wholesale dismantling of a body of case law that this court should, in our respectful submission, outside the issue of judicial hierarchy, be respecting.
Can I ask you this, which I was going to ask before? As I understand it, one way of understanding your submissions on the external event issue,
yes, my Lord,
is to say that factually, where there is an external event,
yes, my Lord,
then principles have been developed with relation to that fact. Where you haven't got the fact of an external event, you are trying to develop those principles by analogy. But it isn't that there is a requirement that there's an external event. That just happens to have been a factual circumstance. Is that a way of understanding?
It's not a way, it is a much better articulation of the submission I've been endeavouring to make, my Lord.
Okay.
The case law is built up in a factual context, not a factual vacuum. The issue for this court is how to apply the core guidance that the court's given in this situation, and the court can see how it's been applied in this situation in cases such as Walters and Renee. And also, at the risk of going backwards, I feel I should cover this off, because although it may be one that's clear and obvious to this court, it is a submission that's being made against me that the claimant has to witness the breach of duty. And I can very short order give my submission in response, which is that would draw the most arbitrary and unprincipled distinction between two types of cases. Those where, like say in a road accident, the negligence immediately precedes the crash. Those where there's a delay measured in a few hours or days.
Well, I don't see how it would cover Hillsborough. The claimants there didn't witness the breach of duty.
No, we're not. But I mean, maybe this is all settled within the court's mind, and I will deal with it and reply if it's necessary. I would simply reference that the Master of the Rolls gives an example of the negligent architect, and there should be no difficulty with that. That's, you can have negligence, a breach of duty, in the way in which you arrange for a building to be set up, which years later collapses. It's never been about the breach of duty. And that is as inconsistent as it gets with the description of the event of injury. Furthermore, it certainly wasn't the respondent's position before Mr. Justice Chamberlain. I'll just give you the reference that there needed to be witness to the breach of duty. Their case has shifted. It's paragraph 63 at page 341. In terms of there being no requirement for the event of injury to be external to the primary victim, first of all, there's no requirement set out in Alcock but event of injury to be external to the primary victim.
Don't start mixing those. So far we've been using the event of injury as being something separate from the accident or the event of accident.
My lady,
but the event of injury is never going to be external to the person who's injured.
Your ladyship's absolutely right. It's much better to describe that there being no need for a traumatic event external to the primary victim. And in our respectful submission, that was not the focus of Lord Oliver's guidance, which at the risk of repetition was in relation to event of injury, was said to be of general application and was going to the core issue of legal proximity. And here I've just referenced the master rolls below at paragraph 37 at page 300, but I won't go to it because I think time is slipping through my fingers. Secondly, there is Court of Appeal authority which establishes that there is no need for such an event external to the primary victim. It is part of the ratio of Walters. And can I go to Walters for this, please? Can we go, please, to page 650? 650. That's Walters. We haven't been to it before, so I'm just going to try and deal with a bit of all in one go before coming back to this submission. If you can kindly go then on to 652, you're in the beginning of the judgment of Lord Justice Ward, and I'm just going to deal with the facts now so they're dealt with once and for all if I can. So from paragraph 2, what the court will see is that the child, the primary victim, Elliot, became unwell. It says 10 months later. I can tell you that the judgment of Mr. Justice Thomas at paragraph 5 confirms that was the 17th of July, 1996. We're happy not to have it. If you wish us to send it through electronically, of course, we will happily do so. So when it says 10 months later, so on the 17th of July, he was admitted to the Prince Charles Hospital when there was negligence, as in a breach of duty, because as you can see lower down, the defendants also accept if he'd been properly, in fact he was suffering from acute hepatitis related to fulminant hepatic liver failure. It's accepted by the defendants he was not properly diagnosed or treated by the Prince Charles Hospital. And they also accept that if he'd been treated, properly diagnosed and treated, he would have undergone a liver transplant and would probably have lived. That means that the case so far is materially identical to Paul, because you have a breach of duty which is silent, because Elliot and his mother don't know this. You have the accrual of the primary victim's cause of action, else the claim would have failed for want of causation. In other words, there's an early breach because there was a delay. As I recall, it was about a week. You'd have to go to London for a liver transplant. So we don't have an ongoing breach right up until the beginning of the event. We can't have an ongoing breach because there has to be time in order to go to London to have a liver transplant to be saved from having the epileptic seizure in the first place. And then we have ongoing symptoms. See the observations of Lord Leggett in the question about angina, because if you see the rest of paragraph 2, he was allowed home at weekends. On the weekend he was brought back to hospital as parents because of their concerns for him. He was a very ill baby. He didn't recognise either his mother or his father. He wasn't drinking. He was irritable and crying. Whereas the event starts on 30th of July 1996.
Sorry to go back, just for my own note, I'm sorry, I didn't quite catch the date when he was admitted to
Yes,
Prince Charles.
17th of July 1996, paragraph 5 of the judgment of Mr. Justice Thomas. And I think
Yes, I just wanted the date. That's very
we will send it through if that's okay. I know it's a sort of you overburned
17th of July.
Pieces, but we will send that judgment first and through.
It was just that date.
Yes, well, so we're not just Paul, we're beyond Paul, because we're not first manifestation of injury, because there is injury, the grumbling. And then we have identification by the claimant of an event, and then the court has to say, is this event of injury one which will permit the claimant to recover as a secondary victim? And because this was a successful claim, we then have ratio, saying this is the position in relation to a successful claim. If I can then take you to page 663, paragraph 29, Lord Justice Ward refers to a case which I'm going to pronounce as Sion, unless told otherwise, against Hampstead Health Authority. Now it's in the bundle, and I'm going to go to it in a moment, but for present purposes, can I just show the court that at the bottom of that page, Lord Justice Ward has set out what Lord Justice Peter Gibson, with whom Lord Justice Waite agreed, said, which is, I can see no reason in logic why a breach of duty causing an incident involving no violence or suddenness, such as where the wrong medicines negligently given to a hospital patient, couldn't lead to a claim for damages for nervous shock. For example, where the negligence has fatal results and a visiting close relative, wholly unprepared for what has occurred, finds the body and thereby sustains a sudden and unexpected shock to the nervous system. Now, I'm just going to dip out of Walters and go to a little bit more of that judgment, if you kindly then go to page 1288. That's the Sion judgment. And if you go to 1294, you're in the judgment of Lord Justice Peter Gibson. And it's the right-hand column where you see the passage in the first new paragraph, so high up, that Lord Justice Ward has quoted from. And then Lord Justice Peter Gibson says in Yainch and Coffey, which is an Australian case, Brennan J. gave his understanding of shock, the sudden sensory perception, that is by seeing, hearing or touching of a person, thing or event, which is so distressing that the perception of the phenomenon affronts or insults the plaintiff's mind and causes a recognisable psychiatric illness. That, in my respectful opinion, encompasses the essential elements of shock and doesn't include the additional elements for which Mr. Whitfield contended. What he contended was, if you go back to the left-hand column at the bottom, Mr. Whitfield submitted the plaintiff's claim couldn't succeed because the injuries to or the death of the primary victim in themselves or itself do not qualify as the horrifying event causing the shock needed for a valid claim. He said it was a precondition of a claim that the incident which resulted from a breach of duty should have characteristics of suddenness and violence additional to the injuries or death of the primary victim. So Lord Justice Peter Gibson was saying, in essence, one, you can have simply nervous shock due to event of injury to a primary victim, and two, you still need that event to be shocking. See the observations from Lady Rose in relation to that, and see the vivid description given by Mr. Justice Brennan in Yainch and Coffey. So we don't do away with the need for the violent agitation of the mind, see per Lord Ackner in Alcock. We don't do away with that at all, but we do away with the need for a traumatic event external to the plaintiff. If you then kindly go back to Walters to page 667, paragraph 45. Like Gibson LJ and Sion, I see no reason why liability for nervous shock in medical negligence cases involves any new application of principle, and that is why, respectfully, I resist continually the observation of the court that we're involved in a new application. We're involved in an application of the principles. The same principle is being applied, even if the facts to which it's applied are new. To act within the parameters of principle does not involve an incremental step. See the observations of my Lord Burrows earlier, much more effectively summarising the submissions I've been seeking to make. So that is Court of Appeal ratio. Of course this court has what I might colloquially describe as the muscle to override that. But this court is coming to this issue today, not fresh, but with the benefit of considered jurisprudence over an extended period of time. That judgment from Lord Justice Peter Gibson was was back in 1994. And it has been working ever since.
Did Lord Dyson disapprove of it?
Lord Dyson certainly, one infers, disapproved of it. He described it as obiter, which one takes to...
He actually approved what Mr. Justice Auld had said, didn't he?
He does.
So there isn't a consistent line since this case.
That's obiter.
Well, I know.
I'm not seeking in any way to deny I would be coming in due course to the
It was relevant to the case before the court, to Taylor and Novo.
I absolutely will be coming to Taylor, my lord. Absolutely. That is an obiter observation, which, if taken to mean, as one would readily infer it is, that is disapproving scion, should respectfully not be followed. In fact, there was binding Court of Appeal authority before Taylor and Novo. Walters, para 45, this is an essential part of the case, because otherwise you don't get there. You don't get to this case because you can't apply secondary victim law to it because it's got no traumatic event external to the primary victim. So it's binding Court of Appeal. It's per incuriam, I suspect, but it's not really because it's obiter. So it's not per incuriam. It's just
what Lord Dyson said.
Yes, it's an obiter observation that, with the greatest respect to a very significant figure over the last many years in the development of the law, is not accurate. So don't take that challenge lightly. And thirdly, denying a remedy to claimants in cases involving no traumatic event external to the primary victim would lead to arbitrary outcomes. And that, what it does is provide an unwarranted immunity to certain defendants, which this court should, in my respectful submission, be able in a straightforward fashion to assess as unfair. There shouldn't be any difficulty for this court in saying to itself that is unfair, because what is happening is a defendant, by the manner of its breach of duty, is precluded from being sued by a secondary victim. Why?
It's quite interesting what Lord Justice Clarke, I think, says at page 668 in Walters, because he does indicate that some of the issues that we've been discussing about whether one is actually developing the law or just applying it, and then he says at the end he sees it as he indicates that as far as he's concerned, it is an application of the law, but in any event, if it did require an incremental step, he would be willing to do so.
Absolutely, my lord. It's a very powerful, short judgment.
But the step he was contemplating was abolishing the need for shock. So it was quite a significant step that he was suggesting that he would go along, and that's not part of your case.
It's not part of my case, my lord. What this part of the judgment of Lord Justice Clarke seeks to emphasise is the submissions which I was going to have made earlier in relation to flexible application, fearless flexible application of the core principles in relation to secondary victims. And that's what I mean by the one direction of travel. If you have a rather graphic description from Lord Justice Ward, paragraph 46, starting at the bottom of page 667 and going over to 668, in which he identifies justice, which I do not, for my part, see as a difficulty for this court to use the word justice, because it is employed. It was employed right back by Lord Wilberforce in McLaughlin, in the passage I took the court to some time ago. Can I perhaps at this point seek to go back and make out my submissions in relation to how the application or refinement of the control mechanisms calls for flexibility, and how there isn't some overarching exceptionality restriction, which is a key component not previously contended for but now argued with vigour by learned friend for the respondents. And our answer to that is in two parts. First, that comes from Lord Oliver in the passage which I think I took the court to, earlier in Lord Oliver's opinion, page 572H. Your Lordships and Ladyship will see, an exception has arisen in those cases in which the event of injury to the primary victim has been actually witnessed. And then, as the Lord Justice Lord Richards read out, that such an exception exists is now too well established to be called in question. And then it's said against the appellants, well, it's all exceptional, so you've really got to restrict the scope. If in doubt, no. And our response is, first, the use by Lord Oliver of the term exceptional in relation to secondary victim claims doesn't lead to the conclusion that the control mechanisms should be applied rigidly. And secondly, the case law is very nearly all one way, namely in favour of flexibility, not rigidity, when applying the control mechanisms. So starting with the first point, Lord Oliver says such an exception exists is now too well established to be called in question. And it's rather like, because we are here in the law of negligence, it's rather like the guidance from the court in relation to the law of negligence, that it's conventional for there to be a duty of care in relation to acts, but less so in relation to omissions. And in Michael and the Chief Constable of South Wales, Lord Tilson used the word exceptionally. So it's exceptional for there to be liability in relation to omissions. And I've taken you to the part of the judgment of Lord Reed in Robinson, where he sets out the circumstances in which there can be liability for omissions. So using the word exceptional in that general descriptive way is unobjectionable. But it doesn't mean, if you're into the consideration of the question of is there liability for an omission and what's the test for assumption of responsibility and so forth, that somehow everything is cast under this shadow that you're now in an exceptional category, so you should construe against. There are rules, for instance, as we know, for statutory interpretation. And it was, for instance, in European law, when they set out a right and then they provided exceptions. The exception has to be construed restrictively. It's as if we're applying this sort of approach because we're in what's described as an exception. But I hope Lord Burrows won't challenge this general analysis of tort law, or what I would call non-contractual obligations law. There is no non-contractual obligation at all, and then it puts statutes to one side, and then the common law has developed islands, or in some contexts, continents, like negligence, of liability. And in the law of negligence, which is its own continent, and over to the other side you've got trespass to the person, you've got nuisance, you've got defamation and so forth. But in that area, there's an island on the edge of that continent, which is the island of secondary victim claims. That's not exceptional in that sense. It's just the law in relation to secondary victim claims, in the same as you've got the law in relation to liability for omissions. And exactly as Lord Dyson says, the courts have managed this area via the control mechanisms. That's the judicial response. So one simply arrives back at the control mechanisms, but without any preconception as to how those control mechanisms should be applied.
But do you accept that, although you say there should be flexibility, there should be the possibility for a defendant to apply to strike out a case and not be met by the argument, well, until you know what all the facts are, because this is all such a flexible test, you can't strike it out, you have to have the whole trial in order to decide at the end of the day whether there was a duty of care?
My lady, yes, we don't make that submission anywhere in writing. You won't see it. We do not say that we should get to trial just because it's a developing area of law. If this court says there can be no secondary victim claims unless there is a traumatic event external to the primary victim, we're out. And you might as well tell us now, it would help me, thank you, rather than go through to trial to discover the same outcome. Absolutely.
It's also important, isn't it, that parties' advisors know with some predictability whether the claim is likely to succeed or not.
Absolutely.
Otherwise, you can't settle cases.
No, and based upon Walters from 2004 with the Court of Appeal binding authority that you can in relation to a case involving primary victim only, the law has proceeded very happily. Absolutely. And as to the judicial guidance in relation to the approach to be taken to the control mechanisms, can I start one step back by again seeking to re-emphasise that we're concerned here with the law of negligence. That is judge-made law, which by definition is flexible and should respond to new situations to achieve justice. And this is put again far more attractively than I can by Lord Scarman in McLaughlin. And can I invite you to go to page 607, please? 607. Which is something of an echo of the passage from Lord Scarman in Sidaway, the Lord Burrows will no doubt have in mind on another occasion. And it's actually all the way from A down to H. So for now I'm going to invite the court, if I may, to sort of what I'd call skim read that page. Extremely powerfully worded. It's not to say that the application of the law of negligence to new situations is guided only by doing justice. It's to say that that underlies it when the court considers how to apply the control mechanisms. And there is a principled approach to the development of the law of negligence when faced with novel situations, and it was articulated most recently by Lord Reid and Robinson. And can you kindly go to page 1198? 1198, paragraph 29. Properly understood, the Caparo case thus achieves a balance between legal certainty and justice. In the ordinary run of cases, courts consider what's been decided previously and follow the precedents, unless it's necessary to consider whether a duty of care arises, hasn't previously been decided. The courts will consider the closest analogies in the existing law with a view to maintaining the coherence of the law and the avoidance of inappropriate distinctions. And that is, we hope, this court accepts, the manner in which we are seeking to make our submissions by reference to the analogies that exist. So in other words, incremental development of the weather eye to maintaining the coherence of the law and the avoidance of inappropriate distinctions. And so the starting point would be to expect the higher courts were prepared to countenance a flexible approach to a novel situation, provided they respect such guidance. And then when we turn to the guidance of the higher courts in relation to the issue of secondary victims in particular, it is all in favour of continued flexibility, the application of common sense, and again I understand one can challenge that and say, oh, justice, common sense, but it's what you're being invited to apply. It's part of the judicial function. And to ensure that a just result is achieved on the facts of a case. And the sole case in which strikes any different kind of note is the Whitend Chief Constable of South Yorkshire Police case and the judgments of Lords Hoffman and Stain, to which I will go in due course. But can I start with McLaughlin, please? And can I go back to the speech of Lord Wilberforce on page 600? 600b. This is the end of his speech after he set out what he calls indications, which we would now call control mechanisms. So I'm at B, the last paragraph. My lords, I believe that these indications, that's the control mechanisms, imperfectly sketched, and certainly to be applied with common sense to individual situations in their entirety, that's the combination of circumstances factor, represent either the existing law or the existing law with only such circumstantial extensions the common law process may legitimately make. So in response to the observations from my Lord Richards, if I'm not simply applying, then please see the language employed by Lord Wilberforce as to what respectfully we say we're doing. And so that's of a piece with what Lord Oliver said, the existence of a combination of circumstances. And such an approach, being highly fact-sensitive, is only consistent with the court's eschewing rigidity in favour of flexibility. And can I then go to what Lord Bridge says at page 620b? Can I now invite the court, please, to read 620b, starting my lords, to the paragraph ending with D, where he says, awareness of mental illness decides. That short passage, please. Very clear guidance to look at the facts, to defer to the good sense of the judge, to recognise that there will be some uncertainty and that is appropriate in the interest of justice. And can I then note... I
mean, the law hasn't gone down that course, and if it had, it would be a mess.
No, my lord, respectfully, that's simply not the position. This basic guidance is guidance which has been operating throughout. If you go to Lord Wright in Borehill and Young, to start with, that is page 835, please, 835. This is the law in relation to secondary victims, and it's not in a state of mess. 835, starting just above the middle, that it may be said is somewhat vague, as the court see that. That is true, but definition involves limitation, which is desirable to avoid further than necessary in a principle of law like negligence, which is widely ranging and is still in the stage of development. And then read further down, and you'll pick up again. The lawyer likes to draw fixed and definite lines and is apt to ask where the thing is to stop. I should reply it should stop where in a particular case the good sense of the jury or the judge decides. Now that sentiment was echoed by Lord Denning in a case called King and Phillips, and the reference for that is page 1095. When he agrees with the analysis of Lord Wright, it's right in the middle of page 1095. If you then kindly go to a case called Attire and British Cass, and this was when a property was blown up by the defendant's carelessness, and the homeowner suffered psychiatric illness as a consequence. So that is at page 792. 792. And here we're in the judgment of Lord Justice Bingham, so this is 1984. And right in the middle between D and E, he says, the suggested boundary line is not, moreover, one that commends itself to me as either fair or convenient. This was a case in which the Court of Appeal recognised they were faced with a novel situation. And then down at the bottom, at H, Insistence that psychiatric damage must be reasonable foreseeable, coupled with a clear recognition that plaintiff must prove psychiatric damage as I defined it, and not merely grief, sorrow, or emotional distress, will in my view enable the good sense of the judge to ensure, adopting Lord Wright's language in Burhan and Young, that the thing stops at the appropriate point. His good sense provides a better, because more flexible, mechanism of control than a necessarily arbitrary rule of law. And in 2004 in Walters, I'll just give you the reference, Lord Justice Ward at 668, again says he applies.
That does seem to be, Atiyah does seem to be taking the view that you said you're absolutely not taking, which is it'll all sort out because she's got to prove causation, she's got to prove that she really did suffer real nervous shock. And if she is able to prove that, well then fair enough. But that means that it's not strikeable out at the note.
My lady, that was a slightly different case because there was, I think, a contract as well, I think. And the directness of the relationship was there because it was British Gas going to someone's home and the homeowner bringing the claim. And I think that's why you're in the world of reasonable foreseeability, and that's why factually it's slightly different. But the sentiment, which is described by Lord Justice Bingham as he then was, is absolutely clear on its face. And turning to Alcock now, if I may, and the guidance that's given in Alcock. So if we go to Lord Oliver at page 573, F. That's where he sets out what he understood to be the common features in the cases up to Alcock. In relation to the first issue, the one of marital or parental relationship only, his response to this, as you see at 577G, first of all he says, in deciding if the court has reference to no defined criteria and the decision necessarily reflects to some extent the court's concept of what policy, or perhaps common sense, requires. And then he says, my lord, speaking for myself, I see no logic and no virtue in seeking to lay down as a matter of policy categories of relationship within which claims may succeed and without which they're doomed to failure in limine. So rigid an approach would, I think, work great injustice and cannot be rationally justified. And he went all the way to considering, if you go over the page between B and C, all the way to considering, like Lord Ackner, that it may be possible to claim as a bystander in an extreme case. The reference for Lord Ackner is 565 E to F, and Lord Keith agreed with that approach, 559 E to F. So there is a really good working example. The rule up until that time, or not the rule, the case law up until that time was only marital or parental relationships. Lord Oliver was asked to throw out any relationship. He didn't. He kept to close ties, but he said it's got to be flexible. It may be that a bystander can claim. It may not be. And why has it got to be flexible? Because that's how you do justice in a case.
No, I'm sorry to go back to 573, but I will.
Yes,
he says at H, it must, I think, be from these elements that the essential requirements of proximity is to be deduced.
Yes, madam.
And he expands the first category.
Yes, madam.
But as we know, there are four others, and we've got the third, which means the plaintiff must be personally present at the scene of the accident or immediately afterwards. Now, I do think what you're inviting us to do is actually to remove that and to say that's not a necessary ingredient. It's not a development or refinement of the third element. It doesn't need to apply. This was an accident case. I mean, Alcock was an accident case. This is not an accident case. therefore you can ignore the third element. Now, that's a perfectly, that's a position you're fully entitled to take. It would represent a development of the law from Alcock. But it is, isn't it, a development of the law from Alcock?
My Lord, I will simply end up repeating the submissions I've made as to whether it's Lord Burroughs put the matter in a way that I would wish it to be framed, which is
that these are elements that are simply arise from the facts of those particular cases.
Elements that arise in that case. When you then seek to apply, if not apply, you saw the language which was employed, I think, by Lord Wilberforce.
If you've got facts where there's no accident, necessarily you ignore the third element.
My Lord,
I don't know why you have difficulty saying that's your submission, really.
I tell you why, my Lord, because I don't ignore it. I just say that the word accident was used in the context of Alcock, but there does need to be, you have to be close in time and close in space to the event of injury.
Well, that's the fourth element.
But it has to be a shocking...
No, my Lord, yes. The third is close, personally present. And the fourth...
the fourth is the injury suffered arose from witnessing the death.
Yes, yes, my Lord. Yes.
So that's different from the accident. The third is the accident. The fourth is the injury resulting from the accident.
I don't just say scrub the third. I say you apply the third in a different context.
But how do you apply it where you haven't got an accident?
Very easily, because you get this interchange in accident and event of injury in that context. If you put in event of injury, you have what I always have accepted is a control mechanism in this context, which is you have to be close in time and space to the event of the injury. And that's essentially, that's what's in the essence of the third point.
But the third point seems to me directed at excluding people who were told about it.
Yes.
So you may suffer exactly the same shock from being told what has happened and having it described to you as you do from witnessing it. But the law says, well, of course, the nearest and dearest are always going to be told about it, so that can't be a control mechanism.
Absolutely.
So that seems to
all
be
part and parcel of that. So I don't strike out the third, I apply it in this context.
I'm sorry, I still don't understand how you apply it where there's no accident.
Well, my Lord, why? The event of injury...
But that's the fourth point.
No, my Lord,
the injury suffered, that's the psychiatric injury, arises from witnessing the death. So that's the other witnessing that has to take place.
Yes, my Lord. And the third says, the plaintiff in each case was either personally present at the, and just read, event of injury.
No, the event of injury is what is subsequent, isn't it? That's the injury.
Well, it may be that...
I don't quite know what I mean, Lady Rose raised this. Talk about the event of injury, it actually means the injury.
Yeah. Well, but I think it's maybe getting at... Yes, you have to... The injury... The psychiatric injury of the secondary victim arose from witnessing the death, that's the fourth element, but that death has to be some shocking event at which the secondary victim is present.
Yes.
Absolutely. So I think the third element is transposed to the shockingness of the death, which is the fourth element.
Yes, again, it's a danger is to read it like a statute.
So you say that...
It's a summary of the case law to date. I think what we can do is articulate quite comfortably what are the control mechanisms in this case. That's straightforward. But my Lord,
I'm watching the clock, and I think
totally
so we'll resume at 2 o'clock. Thank you.